going to try to get you involved and finish our talking heads part, allowing time for you. I could go on at great length about our topic. Our heading of our topic is the use and abuse of discovery in class actions. Well, the reason I could use up all your time is that I've been deeply involved in the third big bad wolf, class actions, MDL, American discovery. There's another big bad wolf that many of you may not like. I've been the guy responsible for writing the American discovery rules for federal courts for somewhat over 20 years. That's more detail than you want. And our topic today You have trouble hearing me?
No.
No, but I need the mic.
Oh, for the recording. For the record.
Well, I'm not sure you need it even for that, but I don't know exactly what value that has either. I think what we need to do is connect up all that stuff with what we're here to talk about, and I think it links up with things we've heard in prior panels, so I'm going to say a couple of things about what we've already heard here during this conference. I'm going to explain why the U.S. has changed in connection with this exact topic, discovery, to get a class action going. Then I am going to turn over to David Lawn to my right, who's with Hausfeld in London, who's going to talk about discovery or disclosure, I guess you call it, in the UK. Yeah. Then Remo Caponi from the University of Florence, who is going to talk about these same kinds of issues on the continent. The goal is that each of us takes about 6 to 8 minutes, and we have 15 minutes or so to find out what you think you would like to hear about. As I said, I can go on at greater length than any of you want to hear. Already what we've heard, for example, yesterday is that in Israel, certification is the full ball game because that means the judge has sort of decided the plaintiffs are likely to win. Whereas in Australia, there isn't any certification. The plaintiffs just get to say this is a class action, and that's that. In the US, as I will say in a moment, things have moved beyond that. The reality in the US is that we not only have broad discovery, but for class actions, that's changed a great deal in the last 20 years. 50 years ago, the notion was the judge can decide whether this is a class action right up front. And indeed, the rule that we had said that must be the first decision and the merits can't be addressed until later. And the idea was, quote, merits discovery, unquote, couldn't start until after class certification was decided. Beginning early in this century, typified by a Third Circuit case, also written by Judge Sirica, who got mentioned earlier today, called hydrogen peroxide, the courts have increasingly insisted that there be evidence submitted to support class certification. And along those lines, Brian in the earlier panel pointed to the need for sufficient data to deal with that kind of problem. That's where class action discovery comes from. And now the big fight is class certification. Yeah. The preponderance of the evidence standard applies to the implementation of class certification criteria. That's not the same as Israel. Apparently in Israel, one says, are the plaintiffs likely to win the case? Here the issue is, do common questions predominate under the evidence that's going to be considered? But you have to know what that is. So, wrapping up my part of the program, in the US in 2015, we further emphasized the notion of proportionality in discovery. With class actions, that is a curveball, because if this is a class action, it's a high-stakes enterprise. But if it's not, it isn't. The high-stakes enterprise we're talking about is deciding whether it's a class action. So that's where the big ball game on use and maybe abuse on either side of the V of discovery in the US in class actions comes up. David, how is it in the UK?
Thanks a lot, Rick. Well, the first thing to say is, as we were hearing yesterday, we don't yet have a very well-established class action regime in the sense of an opt-out action. We have it only in the context of competition claims, and we've only had a few decisions to date. So I'm going to talk about disclosure, as we call discovery, in a slightly broader sense to refer to collective actions, group actions involving specified numbers of claimants. And keeping things very high level, just to introduce how we do it in the UK, we have a very well established and extensive disclosure regime. So the key principle is that we have a cards on the table approach. So that means that in addition to disclosing documents you rely on, there is an obligation to disclose documents that are adverse to your case. And that's one of the key distinctions between disclosure in England and Wales and the other jurisdictions in Europe. And I think that's particularly important for collective redress because, again, as we were hearing yesterday, there's often an imbalance of information. So you often have alleged conduct that is secretive, so whether it's a price-fixing cartel or a consumer scandal such as the emissions scandal, or whether it's alleged defrauding of investors on a securities market, you have conduct that is peculiar to the knowledge of the defendant. And so discovery plays a very important role for claimants in establishing their case. There is an obligation on the defendant to disclose documents that reveal the extent of the misconduct. And you might say, well, public enforcement plays that role, so public regulatory authorities will investigate and publish their findings, and that's how you cast light on misconduct. But I would say that that only goes so far. There are limits, and increasingly, regulatory decisions are negotiated outcomes. So, for example, in the space of competition law, European competition decisions by the European Commission are increasingly settlement decisions which now contain less information about the operation of the misconduct. So that's where I think disclosure plays a very important role in the UK in these sorts of cases. It's not perfect. We have abuses as well. So we have fishing expeditions by both claimants and defendants. We also have document dumping. So as an example of that, last week one of my colleagues was involved in a case. It's worth around £3 million. He got the first tranche of disclosure from the defendant, and it was 27,000 documents. And although we have things like technology-assisted review and the increasing use of AI to manage the proliferation of electronic disclosure, it's still quite early days, and it remains a very complex and costly part of litigation. And costs, I think, is the biggest issue that we have with disclosure in the UK, because you might say, well, in group actions, most of the disclosure falls with the defendant, and so the costs may be large, but they're the defendant's costs. But we have cost shifting. So we have a loser pays rule in the UK, which means that although the disclosure burden may fall mostly on the defendant, if you lose the case, then you're going to have to pay a substantial proportion of its costs. And I'll give you an extreme example of that. That was the RBS rights litigation, described by some as the biggest case in English legal history. I mean, at least in the sense of costs it was, because it was a securities action brought against RBS by various investors who alleged that it had misled them in connection with a collapse in its shares. And although the case settled, before it settled, RBS had spent over £100 million in costs. So pretty extreme. And that was therefore a contingent liability for the claimants bringing the action. And although they included large financial institutions, they also ranged through to consumers, and each of them had a liability for a portion of the bank's costs if the litigation were not to succeed. So that's an extreme example, but cost, I think, is the biggest issue that we have disclosure. So just briefly, 3 things we're doing about it. Firstly, we have rewritten the rules. So in January of this year, we started a pilot scheme which applies to disclosure apart from in competition cases. And so I'm working on a case to which the pilot scheme applies. It's very early days. The same principles are there, so a positive duty to disclose adverse documents, but it's also, I think, the idea, after lots of rumination and discussion between lawyers, the idea is that we should not be seeing it as an adversarial part of the litigation. We should be seeing it more like a project management endeavour where the parties are supposed to collaborate, the solicitors are supposed to hold regular, cordial meetings, and we'll see how it goes, but there is a sting in the tail in that the courts can sanction parties through costs if they don't behave properly. So it's early days, but I'm optimistic that that will address some of these issues. Secondly, just to talk about collective proceedings orders, although we've only had 2 decisions to date, I think the clear intention, when you look at the guide to the Competition Appeal Tribunal, the intention is that you don't have our equivalent of class certification becoming a mini trial. There isn't expected to be extensive evidence disclosure. So in fact, the CAT commented on this in the first decision, the mobility scooters decision. It commented on the fact the intention is there to be either no or very limited disclosure. So there is a clear intention there. And more generally, the CAT has wide discretion as to how disclosure should be ordered. So it's not automatic. The CAT has the ability to order the type and timing of the disclosure to be given. And finally, just again on costs, we have a very vibrant litigation funding market in the UK, and that's very important for collective redress, because if you have a consumer or a consumer rights organisation, you obviously have to fund a case to budget for extensive disclosure, but you also have to deal with the adverse cost liability, and that's where funders can step in to make these cases viable. So just to conclude, I would say that we've seen some developments on disclosure in Europe recently, the damages directive in competition space, the very recent consumer redress bill. They both contain limited provisions for disclosure. And I think there is a recognition in Europe that with these types of claims, you have an information asymmetry, and that disclosure is a means to address that imbalance. And the UK, as a mature and well-established jurisdiction, I think, is an attractive forum for those kinds of claims.
Thank you, David. Just a footnote, I want to drive home a point that he just made, which is, compared to what I said to begin with, as we move over, segue to continental Europe, compared to the UK orientation to simplify, not overload mini trial certification, we are at that point with experts and other things, multi-day hearings, a lot of evidence, therefore a lot of discovery. Raymond, tell us about what's going on the continent.
Yeah. Thank you, Rick. I will try to be brief, as you have to leave early, but English is not my mother tongue. Should I speak Italian in order to be faster?
Sure, fine with us.
I mean, it's, to be fair, to be fair. Oh, no. Next time. I mean, I will try to do a short comparison between continental and common law. And the first point, the starting point, as a matter of principle, as you know, rules concerning gathering of facts, access to information and evidence do not differ in class action proceeding in comparison with all other civil procedures, at least in the Italian legal system, but I guess it's the same in the continent and more or less in the US. And it is common knowledge that the requirement of entrance into fact finding in civil procedure are quite different across civil law system and common law system. Very different are in particular the exact requirements of necessary particulars of the party assertion of facts and of the necessary specification of the means of evidence. Under the traditional understanding and practice of the US federal rules of civil procedure, relatively poor factual details are enough to open the door for discovery and disclosure of facts and evidence by the opponent or even third parties. Whereas in the continental procedural system, the continental procedural system, like the Italian, German, French, and Spain, require assertion of all relevant detailed facts which are necessary for the success of the claim or defense, and additionally, the offer of specific means of evidence already in the pleadings, and in principle they do not permit any steps toward disclosure or taking of evidence without fulfillment of these requirements. And then we have further differences. Continental courts exercise a strict control of the relevance of asserted facts for the legal theory that underlies the party's case, and must issue a judgment on the merits without any taking of evidence against the claimant or defendant who fails to assert all relevant facts necessary for success of their case, whereas the US American civil procedure does not provide such a strict control of relevancy. This sounds very much like we are talking about totally different worlds. However, both models of opening the door for fact-finding and evidence, evidence-taking, had to make concession and to modify the rigidity and absoluteness of their approach, and consequently both models include in practice some key elements of the other model into their conception in order to avoid too radical solution. For example, I'll give you two examples, one from the Continental model and one from the US model. The Continental model had to cope with the problem that in some cases a party has really no any detailed knowledge of facts and means of evidence because the relevant facts occur in the sphere of the opponents or third persons. In these cases, Continental courts do allow to permit the assertion of very general facts that are kind of repetition of the requirements of the legal basis of their case, then a detailed description of asserted events, and accordingly the specification of means of evidence describe kinds of classes of documents or witnesses or ask for expert evidence without a clear idea of factual events and detail of asserted causation. Instead of detailed facts, parties have to show plausible grounds for their factual conjecture. In German, they call this Anhaltspunkte, in French, fait sérieux. In Italy, we tell about verisimiglianza. I think it's the same.
So you are using Italian?
Yeah, that's it. Yeah, that's it. No, a little bit. Yeah, you should learn Italian.
Molto bene.
Yeah, okay. That's just an example. Our system is moving toward the in a way the common U.S. American approach, at least in certain kind of cases. On the opposite side, as you know, I don't need to tell you that, but nevertheless, I have still 2 minutes and I will tell you. In more recent times, the US American Supreme Court affirmed summary judgments that dismissed claims for damages without granting disclosure or discovery because of lacking particulars in the pleadings and insufficient plausibility of asserted misconduct. Took the events happened in the opponent side. Right. So Twombly and Iqbal, and you know, in the reality, very different system in their starting point are moving towards each other, and we need to move also toward the U.S. American model regarding the class action, and that's our problem. But boy, now I will stop. Maybe I can tell you a little bit more.
Well, thank you, Remo. And
You made a big pressure on me. I had to talk. I could tell. I don't know hours.
Yes, I made a big pressure.
I mean, you have to come to Italy.
Yes. So therefore, thank you to both my colleagues. I hope we can hear from you. We could talk at length about what interests you or what interests us, but probably it makes more sense to talk about what interests you. So why don't you tell us? Yes?
In the context of GDPR, I'm aware that some companies have been worried about retention over their data and some of their retention policies, and have been effectively deleting and getting rid of lots of stuff because they're not able to comply with these restrictions. So how does this interact with Discovery?
We have a new Rule 37E that went into effect on December 1, 2015, dealing with preservation of electronically stored information, which I assume is 95% of what you're talking about. It doesn't fit with the prior EU privacy criteria, much less the new ones, or at least there's a big tension.
Yeah.
I am not clear on whether, under the prior view or the current regime, preservation that we say you are supposed to do to avoid problems under our rule is considered processing that violates your rules.
Yeah.
Frankly, that's a face-off that I am not aware has really reached complete fruition. We'd be delighted if you would back down. And you might be happy if we'd back down.
No.
But I don't know that either side is going to back down on that. And I think that's a US versus the world kind of problem. And I'm not saying the US is right and the world is wrong, but it is a big problem.
Yeah, if I may add something, I must say, I very much like the American way of life. I was 1 year in the US, and I learned in civil procedure from Sammy Zakharov, and I like the American way of thinking, but in this way, I participated attended many seminars about these problems, this difficulty between Europe and America. And my idea is, in the end, towards us, you practice what you say. We should the efficient breach of the law. The American discovery is the efficient breach of the European law on privacy. That's my point of view. Or would you not agree? And of course, for us it's something problematic, but we used to respect the rules, and the American goes straight to the outcome in a way. It's a different way of thinking. We have this morning, Sam, it was telling about output legitimacy in a way, or not. And I know I am exaggerating, but in the end, that's the different. We like values, and the privacy, and you get straight away to the outcome. Money. It's not only about money. I know. Not only about money, but in the end, you make big money, and where will you spend this money? In the middle of nowhere? Probably you will come to Italy. And as you like your job, you will combine good food and good weather with civil procedure. That's the real reason why Italian civil procedure lasts so long. So you have the occasion to come again in Italy. That's the difference. We are totally complementary. You make the big money and then you spend it in Italy.
Well, wait.
Sorry.
Point of personal privilege. I come from San Francisco, and we have good weather and good food, too.
Just to, again, follow up on the GDPR point, I mean, obviously it's early days, you know, in the UK as to how this is going to work, but just thinking about it in the litigation context, if you are contemplating litigation, there is a duty to preserve documents. It's a very wide duty. It's expressly there all over the new rules. This is something that legal advisors have duties in respect of as well. That doesn't completely solve an issue, of course, because that's at the point when the misconduct is perhaps identified within an organisation. But I think perhaps this is also, if you're thinking about what to do with vast amounts of data, you know, ephemeral communications like chatting, that sort of thing. And if you think about the banking sector and the various scandals that came out of that, so the benchmark manipulation cases, a lot of the key evidence was Bloomberg messages. And as I understand it, most of the banks have now banned that kind of communication. So perhaps, you know, if you're thinking about in-house lawyers and they're thinking about risks and they're thinking about things like messaging, perhaps they're taking a different approach to the preservation of data in the first place.
Can I say something about that specifically?
Go, please do.
So, it really depends on your case. Before GDPR, we had the directive and every country implemented their version of it. So what we used to do is, really depending on the client, if we needed to seek consent from custodians for preservation, we did that. In some instances, we just entered into model clauses and we transferred everything to the US to the model clauses with the understanding that production to a US court or regulator is not covered by model clauses because the court or the regulator was not a party to the model clauses. And so we try to work with the privacy regime with the understanding that it is not airtight. But if our practices were challenged at the time, we could show that we wrapped our hand around privacy and we tried to tackle it. With GDPR, you know, it introduces another set of complexities. I haven't had a massive cross-border discovery case since it came into effect, but I think that at this point I would just use the same set of tools, model clauses, if I need to. Seek consents. Of course, some cases you cannot seek consents, the FCPA or anti-bribery law cases. But right now, it's basically to try and minimize exposure, try to preserve as little as you need, focus on certain high-level people so their consent is more informed. But at this point, it's a direct clash, and so that's the cost of doing business in the United States. And 27,000.
Yeah, I would. I thought you were going to say 27 terabytes. Yeah, well, the Sedona conference 5 years ago came up with a modus vivendi that ideally might have put a buffer in between U.S. discovery and then existing EU preservation requirements. I would note from the U.S. perspective, and not so much for class actions, but for other sorts of litigation, it is no longer true that there is one-way discovery in the sense that used to be true, because so many individual Americans have so much social media data that there's a preservation obligation there also. And so discovery from class members, something that's been verboten for a long time, is perhaps going to be relaxed. Discovery is a two-way street in class actions also. And the EU or the rest of the world's privacy emphases are just another illustration of the abiding tension between U.S.
Yeah.
I'm in defense of you. It strikes us, as Mirjan Damaska once said, that it's remarkable that the Europeans are willing to accept results based on such limited information as they get their hands on. And what we get our hands on is a lot more comprehensive in a day when people do use Bloomberg, do use many other things that create records, if you want to call them, that can be found. And along with CCTV. we can find out a lot about what happened, and I'm not clear why privacy means you can get away with your illegal stuff because you want to use the right to be forgotten. We have a Fifth Amendment privilege against self-incrimination in criminal cases, but not in civil cases.
Yeah.
Sometimes it seems in Europe that it's the other way around.
Yeah,
Back.
I did.
I was wondering if you can explain the pre-trial discovery procedure used in the US, and I was wondering what is your opinion if it doesn't make defendants settle unmeritorious cases.
No, but
Too early.
Ari, say again, the what kind of discovery?
Pre-trial.
Oh, well, here's the question. I think, let me see if I got your question right, because this poses another thing that people say is a myth on the one hand and is prevalent on the other hand. Can people extort, overstatement, money from defendants by making broad discovery requests? Is that what you're talking about? Yes. Well, judges like Judge Dow are on the lookout for that. Certainly, defendants claim that happens. I've even 20 plus years ago heard defendants claim that plaintiff lawyers ask for stuff they already have in order to seek sanctions when the defendant doesn't turn it over, and the plaintiff lawyers can say, see, they didn't give us this one. I don't know. I'm sure there are some examples that are sort of like that. And frankly, I suspect there's an equal number of examples where, call them defendants, large organizational parties played hide the ball and did hide the ball and kept the ball hidden. That's a trade-off that we ask judges to try to broker in individual cases. In terms of proportionality in class actions, that's where the stakes are highest. And you might say the objection to broad discovery there is harder to understand where the stakes are so high compared to individual litigation where they may be much more modest.
In my experience, and this is in response to Ariel's question, it's much more common for defendants to impose burdensome discovery on plaintiffs in an effort to get them to drop their claims than it is for plaintiffs to try to extort settlements by burdensome discovery requests from them.
In 1998, the thing we did that pleased the plaintiffs bar most was the 1 day of 7 hours limitation on depositions, because plaintiff lawyers in some cases, say employment discrimination cases, found their clients were being deposed for maybe weeks on end and just worn out. I mean, that's a story we heard, but I think, again, there's ammunition for complaint on both sides.
Yeah, underlying this whole debate about discovery disclosure is, of course, a sort of trying to find a balance between, on the one hand, the desire for as much information as possible, on the other, a sense of what is not only cost efficient but proportionate and in the case and the circumstances. And I want you to just explore and welcome, Richard, if you can say more about, specifically in class action discovery, the question of discovery from claimants, from the members of the class. And that's particularly acute, as David has described, where we have class actions, and I referred to yesterday, in competition cases. And unlike your federal courts, well, I think your state courts are different, state law is different, we have pass-through. And pass-through defense means that the defendants, say in a cartel, can say, yes, even if there was an overcharge, you claimants passed it on to your customers, and that immediately opens the question of discovery from the claimants. How do you handle discovery from class members who are, of course, not all...
Well, I think this is directly responsive to what you're saying. I don't think it has changed. It's been around for a long time. What's the easiest thing in the world for a defense lawyer after a class has been certified to do, say in a competition case? Send an interrogatory asking the plaintiff lawyer to answer with respect to every member of the class tell us the date you bought our product, tell us how much you paid for it, maybe tell us if you still have it. And there's 10,000 answers to be obtained. 40 years ago, American judges concluded that is pointless, and while you can take the deposition of the class representative, and people do that, the only way you can do that kind of discovery with respect to unnamed members of the class is by getting the judge's advance permission. Now, maybe in your situation with pass-through, we've got Illinois brick, but in your situation with pass-through, there would be a little bit more leverage for doing that, but I would think a judge would be more inclined to look to some quasi-administrative method of claims processing to determine in a class action which people are entitled to what amounts, rather than something like discovery where if you don't send something in time, your case can be dismissed. That's a headache to be avoided. In most cases then, in class actions, there's a pretty good insulation for the plaintiffs against discovery. But they may have to come in later as claimants to show that they're really entitled to X dollars, pounds, whatever it is, euros, whatever we're talking about. So I think that that's probably still in place, that this protection of unnamed members of the class. And I don't know what you do in England.
Well, just it would be helpful, I think, just to mention a slightly different context is securities action. There's an ongoing case against Tesco coming out of an accounting scandal in 2014, and a large group of mostly institutional investors are suing it, and they have to prove that they relied on the misleading information. And that there was a hearing fairly recent. It was a case management conference, and the judge was trying to work out how best to manage evidence, so disclosure by the claimants. And the claimants were saying this is going to be unmanageable if each and every one of the claimants has to give extensive disclosure about each of the individual fund managers, the basis on which they relied on decisions. It's going to be, as a matter of case management, disproportionate. So they were seeking to persuade the judge to impose a test case scenario where a select group of the claimants would give disclosure, and then the court could determine whether it could determine some common issues from that, and then if necessary, the remaining claimants would give further disclosure. And interestingly, the judge rejected that submission, and as things stand, all of the claimants are going to have disclosure. And the judge was very worried about whether or not in the long term it was going to be helpful to have a test claimant procedure. But it was clearly something that he, I think, was struggling with, and the claimants have the ability to go back to court if it turns out this is going to be a very disproportionate exercise. So it's something that I think the English courts are definitely grappling with in the context of collective actions.
I think I'm getting the high sign, or the low sign, that our time is up. Thank you very much for your help.